joining us remotely or virtually today. So really appreciate you guys coming out. Years ago, I had an attorney when I was young in my career. I had an attorney explain to me that the pro-fraud lobby in government is very small. It doesn't matter which administration is in power. The pro-fraud caucus is very, very small in any government. So testament to the topic and everybody's interest in this matter today. A couple of housekeeping items. For those here in the room, restrooms are just around the corner. So if you go back out by that table that you saw, you just hang a right and we've got restrooms right there. For those that are virtual, we are going to have a virtual chat function. So feel free. Katie is monitoring the chat, and we'll usually, unless it's something that is just, needs to be answered right away, we'll usually kind of gather all the questions at the end and then share those with David and Bob and make sure that your questions are answered out there in TV land. As well, I have some colleagues. My brother Bartley is back in the back of the room and is joining us today, and my colleague Tammy Johnson. And I already mentioned Katie is here in the room with us, and Jess back there taking photographs of our event. So just wanted to introduce them real quickly. We have the great pleasure of having two distinguished attorneys with us. We have been writing this kind of insurance for years and years as a firm, and have had great experience. Our clients have had great experience with Parker Hudson Rayner Dobbs. I want to introduce our two speakers today, and then I'll get out of the way. First up is Bob Brennan, and Bob, in this order, education went to Vanderbilt, then to Georgia State for some graduate work, and then on to the University of Georgia, where he got his law degree, and then ended up being an assistant U.S. attorney before he got out into private practice. And then David O'Neill also had a tour in Athens, undergraduate in Athens, and then went to Ole Miss for law school, and then also is an assistant U.S. attorney. So you've got two guys that formerly prosecuted healthcare professionals on the other side, and then now are in my worldview, wearing some white hats on this side of the equation. So with that, I'll turn it over to you guys. And again, if you have any questions here locally, just raise your hand, and then out in TV world, let Katie know through the chat, and we'll get going. Thanks so much.
Thanks, John. Hi, everyone. As John mentioned, David O'Neill and Bob Brennan were both with Parker Hudson Rayner Dobbs here in Atlanta. We have a pretty ambitious presentation for you all today with very ominously titled "When the Feds Come Knocking." But we're going to cover just sort of how a healthcare fraud investigation may work from inside of the government. Both Bob and I spent time with the government. We'll talk about that type of thing. And also give you some practical advice if you have the misfortune of having to encounter federal agents investigating healthcare related cases. We can talk about some recent cases involving physician practices that may be germane to you all. Briefly touch on insurance. And most importantly, we want to answer questions that you all have and help you understand sort of the contours and the intricacies of a federal investigation. So Bob and I both did stints with the federal government as prosecutors, as John mentioned. Mine is really recent experience, actually. I until last September, I was an assistant U.S. attorney here in Atlanta, where I was an AUSA for about 11 years. About half of that time, I was doing False Claims Act investigations and litigation for the government. And the second half, I was doing criminal healthcare fraud investigations and prosecutions. And so I have some recent experience to draw on to sort of help give you all a later when it comes to federal enforcement. Bob, I'll let him give his bio, but he's certainly spent a long time both inside and outside of the government.
Sure. So I started out of law school after a clerkship with King and Spalding, doing healthcare fraud, civil fraud, FCA type cases for a gentleman there who had a big practice, and that spurred me to want to go to the government. So I went to the government in the U.S. Attorney's Office out in Savannah for about 4.5 years. We moved down there with one kid. By the time we had our third kid, it was time to come back to Atlanta, where we had parents who could help out with our family. I joined Parker Hudson You know, when I came back from Savannah, I know that was a little more than 18 years ago because my third child is a senior in high school, about to graduate. He's 18 years. So I've been at Parker Hudson for about 18 years. One of the reasons I joined Parker Hudson is because they had an established healthcare practice representing provider, representing health systems, physician practices, clinics, DME providers, other types of providers. And that was a real, a big plus for me because that's the type of people I wanted to represent in government investigations. So for the last 18 years, I've done several different False Claims Act investigations, both, you know, when the practice or the health system gets the initial document, the civil investigative demand, or the grand jury subpoena, all the way through to litigation, even after you've convinced the government to decline the case. If the relator is counseling the relator, the whistleblower, they want to move forward into just traditional litigation. I've done that as well. So kind of from soup to nuts for the last 18 years. And I've enjoyed working with John and Bartley and helping out folks who avail themselves to insurance coverage that may be available for these type of cases as well.
All right, so I'm going to start by giving you all just an overview of what a federal healthcare fraud investigation might look like. There really are two types of cases, and the critical distinction within the DOJ is there's the civil division and there's the criminal division. And so the important thing there is criminal division is doing investigations where they are looking to see whether someone committed criminal acts. And the end result of those investigations, if they bear fruit, is that somebody very likely goes to jail. Civil False Claims Act investigations, on the other hand, are a primary mechanism where the government seeks to recover not only the amount of money the government may have lost through healthcare fraud or waste and abuse, but also impose penalties and multipliers on that amount to deter folks from doing that thing, those types of things in the future. And then there are, of course, parallel investigations where both the civil division of the DOJ and the criminal division of the DOJ are investigating the same conduct because the same conduct puts somebody in jail and results in false claims act investigations. So in those cases, both the civil prosecutors and the criminal prosecutors are working in tandem. All right, let's go back one. So for criminal investigations, the primary tools, the arrows in the quiver of the DOJ really are the criminal healthcare fraud statute and the anti-kickback statute. Now, that does not mean there are not other statutes that might be the subject of a criminal healthcare fraud investigation. There's the wire fraud statute. There are other more specific statutes, but these two are the biggies for the government. And the criminal healthcare fraud statute, importantly for you all to know, it applies whether the conduct relates to government insurance, so Medicare and Medicaid, or private insurers. And that's a real critical distinction here when we'll talk about the False Claims Act in a moment, or even the anti-kickback statute, which is both a criminal and civil tool. You know, those types of statutes relate only to government payers, so Medicare and Medicaid. Criminal healthcare fraud statute can be conduct that is vis-a-vis a private insurer or a government insurer. And so that the reach is much broader there. And that's important to know, especially because violations of the criminal healthcare fraud statute can land somebody in jail for, generally speaking, up to 10 years. It can be up to 20 years if the conduct relates to physical harm to patients and things like that.
One other thing on the criminal healthcare fraud statute, private insurers oftentimes will have their own investigative arms. It's SIU, Special Investigating Units, often made up of former FBI agents or former HHS agents. And they treat it like they're still criminal investigators. They're building the case, and oftentimes they will try to present their cases to their former colleagues at the Department of Justice, trying to get them to take the case and to make it into more than just a commercial insurance dispute, into a criminal investigation.
I would go once a quarter down to Anthem Blue Cross Blue Shield here in Atlanta and attend these quarterly meetings for the healthcare fraud working group, in which everybody would sort of compare notes about what they're seeing. And it's a good ego boost for me because I was the most popular person in the room, because all the SIUs would come up to me after the meeting and try to tell me about what they've been seeing and try to get me to take a case that they thought might be good. And so you better believe that the government and the private insurers are comparing notes and talking about what they're seeing and analyzing data and statistics and finding providers that they believe are committing fraud. And so that's important to keep in mind. The other primary tool is the anti-kickback statute. I think most folks are probably at least generally aware of that, but it prohibits either paying or receiving remuneration in exchange for healthcare referrals. This is, and we'll talk about it, oftentimes the subject of a False Claims Act investigation, but many folks don't realize that this is a criminal statute. This also can land you in jail for up to 10 years. And so it is when I was a criminal prosecutor, one of the primary tools that I used. It's easier oftentimes to make a case under the kickback statute than it is the healthcare fraud statute, because it's more cut and dried. And then briefly, most folks think about whistleblowers in the context of the False Claims Act, but the DOJ has a new program that they rolled out last year, this Corporate Whistleblower Awards pilot program. And very much like the False Claims Act, it incentivizes people to come forward who know about possible criminal violations by promising them a portion of the government's recovery in criminal forfeiture. So you can think of criminal forfeiture where the government comes in and takes assets of a criminal defendant that have been obtained through fraud. And so if the government collects some of those assets, then the whistleblower can recover some. So you've got whistleblowers on both the criminal and the civil side.
Quick question, is it SUI or SI?
SIU.
SIU,
So
so,
Special Investigations Unit. is
so
what-
when those folks get together with the payers, are they prohibited from mentioning the client's names?
No. No, in
Work
fact,
for the payer, right?
Yeah.
they work for the payer, and in those meetings, they talk about, hey, we've seen this provider, and they will name the provider. Have you all seen the same thing? And if folks have, they'll say so. If they haven't, they'll go back and look. And so they are very much comparing notes.
Thank you.
Okay, on the civil side, obviously the False Claims Act is really the investigative tool that's used to recover billions of dollars per year in fraud, waste, and abuse. And False Claims Act, very similar to the healthcare fraud statute in that it penalizes knowingly submitting false claims of the federal government for payment. What it does is it imposes what are called treble damages, and that's where the government recovers 3 times what it paid for the false claims. And the single damages is restitution, and then the 2 times multiplier above that is really to disincentivize folks from doing that type of conduct in the future. And then on top of that, and this is the biggie, there are per claim penalties, and for every false claim that's submitted. These things add up really fast. Statute says that they're between $5,000 and $11,000 per violation, but that is subject to being increased for inflation. And right now, those, instead of $5,000 to $11,000, they're almost $14,000 to almost $28,000 per claim. So you can imagine if, let's say, you've upcoded, the government says you've upcoded 1,000 claims. That's 1,000 times up to $28,000 on top of whatever the treble damages are. So False Claims Act is a really, really powerful tool through which the government enforces the healthcare fraud or investigates healthcare fraud.
And just per claim penalties is really a key issue, because it is mandatory if you go to trial and lose, that the judge has no discretion. He has to impose those per claim penalties. And that can turn in, there's a great example here in Georgia where a doctor went to trial. It was about $1 million worth of, damage to the government. And because of the personal penalties in which trial lost, became a $27 million verdict in judgment against this stock. And that's the trial penalty. The government knows about the trial penalty. The relator and whistleblowers council knows about the trial penalty. So oftentimes for our clients, the prospect of saying we're going to fight him, we're going to go to trial is just not something, even if you have a strong case, that makes sense, because it's more than a bet the company type proposition. It's you'll be out of business if you lose. So oftentimes you have to, as hard as it is, you have to try to negotiate some sort of resolution that takes away that sort of existential risk to your business.
And the corollary to what Bob's saying is that the government will, generally speaking, take penalties off the table for settlement purposes pre-litigation. And so, I mean, like you said, if we're dealing with, $1 million in potential damages to the government, but then $27 million in penalties, that's a $27 million savings for resolving it early. And then the anti-kickback statute and the Stark law, the self-referral law, they're also predicates for a False Claims Act violation. So if you violate the AKS or if you violate the Stark law, you've also violated the False Claims Act. And so frequently speaking, you've got investigations for the anti-kickback statute, which is a criminal statute, but those violations may put somebody in jail and land them with some False Claims Act liability. The Stark law, as folks I'm sure have heard of, is a strict liability statute. And so either if you violate it, there's not a lot of argument to be made about whether you had the intent to do so. And so that's also a powerful tool for the government. So this is important, and these are the jury instructions from the False Claims Act trial we just discussed. And this sort of highlights where civil violations under the False Claims Act and criminal violations are different. So with criminal law, you have to do things, willfully and knowingly, which basically means you have to do it on purpose, right? You have to be trying to defraud the government out of money that you're not entitled to. False Claims Act is called a fraud statute, but it's really not a fraud statute, right? It can be violated if you do things on purpose, but it can also be violated if you have what's called deliberate ignorance of the truth or reckless disregard for the truth or falsity. And this is from that trial where they give these instructions, and what they said to the jury when they were instructing them to go back and deliberate is that deliberate ignorance encompasses defendants who are aware of a substantial risk that their statements are false, but intentionally avoids taking steps to confirm their truth or falsity. So what does that mean? That's putting your head in the sand. So that's the ostrich putting his head in the sand and say, I don't want to hear anything, don't tell me if this is true or false. That's a False Claims Act violation. Reckless disregard is something akin to gross negligence. Basically that you might not have specifically been trying to defraud the federal government, but there was something that you knew where you were like, I don't know that this is okay, but I'm going to do it anyway. And if there are emails that the government's able to get their hands on where they can show, look, these folks knew the right way to do this and instead did not do that, whether it was an intentional thing or not, also a False Claims Act violation. And that's really important to understand. And we'll get into how the government investigates and how you respond to that investigation. But this is not always, and in fact, generally speaking, very frequently is not folks that have tried to go out there on a deliberate scheme to defraud the government. And that doesn't mean it's not a False Claims Act violation.
Yeah, David mentioned emails, and emails are often the source of what we call intent evidence. How's the government going to prove that this is just more than an honest mistake, and it's somebody knew something and should have done something about it? Well, they're gonna ask for emails as part of the subpoena process, and they're gonna piece together emails and try to show, there's a pattern that you knew there was a problem, and maybe someone down below you was raising these issues and you just never did anything about it, or you said, well, we'll get to that eventually. And sometimes the emails can be pretty innocuous, but when you string them together, it sort of supports the government's narrative And you constantly are trying to have to kind of say, well, you have to read that in context. You have to kind of understand what was going on. And that can be challenging, 5, 7, 8, 10 years ago to kind of recreate what's going on as to why a certain email was sent or a response was sent.
Same thing with policies and procedures. Having really good policies and procedures is great if you follow those policies and procedures. If you have a policy and procedure that's textbook correct and it says the correct way to do something, and then you do the opposite, well, the government's going to say, see, you knew how to do it, and you didn't do it. And that is at least reckless disregard. I wanted to briefly touch on the retaliation provisions under the False Claims Act because this comes up a lot. False Claims Act prohibits retaliation against folks that are essentially blowing the whistle internally, either with the company, telling the company what's wrong, or who have reported misconduct to the government. So you can't, under the False Claims Act, terminate those folks, demote them, harass them, or take other, generally speaking, what the employment law folks will call adverse employment actions against them for whistleblowing. So this comes up a lot when folks have reported, but it also comes up a lot in termination contracts or severance contracts with departing employees. Sometimes practices will try to bake into those agreements sort of prohibitions on reporting things to the government. You can't do that. Those contracts are going to be null and void under pretty much every court to have looked at them. There are certain things you can do, right? You can prohibit them from seeking maintaining retaliation cases against the practice. And there's some other contours that could be the subject of a whole nother presentation. If folks have questions about that, we're happy to provide more detailed answers, offline or after the fact. But just wanted everyone to be aware that this anti-retaliation provision does exist in the False Claims Act. Okay, so let's talk about how the feds are going to investigate a case, whether it be a criminal or a civil case. So in the criminal context, the government has some tools that are not available to the civil folks. And they have some tools that are generally speaking going to be used in any investigation, whether it's criminal or civil. So the government is always going to do what are called informal interviews. They're going to go speak to folks that would have knowledge about what they're investigating. And what does that look like? We're talking about gun-toting federal agents, so either with FBI or HHS, Office of the Inspector General. These are federal agents with badges, and they will go set up meetings with folks, sit down with them, talk to them about what they know, and they will write what's called a memorandum of interview, where they document what that person told them. And those are sort of part of the investigative file that goes to the government. You can also do stuff more along the lines of what you might have seen on TV, undercover operations. And so there have been healthcare cases in the past where HHS agents, pose as Medicare beneficiaries and go into a practice and surreptitiously record encounters with physicians, depending on what's being investigated. Those are things that can be done. When I was with the government, they're not done. There's a lot of hoops you have to jump through to do those. They're not as often used of a tool in healthcare fraud. All the time they're used in DEA investigations, so sort of opioid type investigations with pill mill type allegations. There's not really a pill mill case that I've been a part of that doesn't at least try to use an undercover. With the healthcare fraud, it tends to be a little bit more difficult and oftentimes not as useful. So that varies. And then there's what you see in the picture here. There are grand jury subpoenas. And so those are subpoenas for either documents or testimony that the government cuts and sends to whoever they think may have evidence related to the investigation. So that could be to the practice that they're investigating, but it could also be to third parties. So it might be a cell phone company for records related to who's called whom at what time, things like that. There are also grand jury subpoenas for testimony. What happens if you get a subpoena for testimony is that you have to go down to, in this district, the Richard B. Russell building. You can go with your lawyer, but you can't go in with your lawyer to testify. And a prosecutor is going to ask you a series of questions that you have to answer under oath. And that is recorded by a court reporter and is part of the investigative file and is part of the record in that case. Your lawyer doesn't get to go in with you. Your lawyer doesn't get to ask follow-up clarifying questions. It's a very much one-sided process. It's very intimidating for folks that have to do it. But it is a mechanism by which the government can, you'll hear prosecutors use the term lock-in testimony. So if we want to get somebody on the record saying what they know about the alleged fraud, grand jury is often the way they do that.
One thing the government generally cannot do, though, with the grand jury subpoena for witness testimony is haul the target of the investigation into the grand jury, because that person has certain rights under the Constitution. So, some people think, well, if you get a grand jury subpoena for your testimony, you may be off the hook because you're not the target. You may be a subject of the investigation. You may be the practice manager for the doctor they're investigating. You still have an obligation, though, to go in and tell the truth. The way you become a target of the investigation is if you then lie, and you lie in that grand jury session, then you can be prosecuted for that.
Yes, absolutely. And then lastly, search warrants. I think most folks are generally familiar with what search warrants are. But it's not just you can get a search warrant to search a physician practice, and I've done that many times. But usually before you've done that, while the investigation is still not known to the target of the investigation, there's oftentimes search warrants for email accounts that are hosted by third parties. There's search warrants for social media accounts and messaging in those social media accounts. Cell phone location data. So if I'm investigating a doctor that claims that they were on a premises doing something at a given time, but I can get the cell phone geolocation data that shows that they were on vacation in Tahiti or the time that they said they did that, that's pretty good evidence that I'm going to use in a criminal prosecution. So, flip side, on the civil side of the house, some of those, more interesting tools are not available, but the civil folks have tools that are really powerful. They can do those same types of informal interviews. Medicare data analysis, I have to say, is something when I joined the government that I did not realize how powerful it is. And there are teams of folks at DOJ that can crunch Medicare data in ways that you could not possibly imagine. They can say, without interviewing one witness, without doing anything, they can say, these providers in your district are very likely committing this type of fraud. And oftentimes that is a way that civil investigations are started. It's not always a whistleblower. It's frequently a whistleblower, and we'll get into the whistleblower cases, but data analysis, these so-called homegrown cases are becoming much more common in recent years as the government has become more sophisticated in data analysis. And then CID, Civil Investigative Demand. These are sort of the civil side of the house's version of the grand jury subpoena. So they can send those to whomever they want. Doesn't matter if you're a target of the investigation or not, and request documents. They can request that you provide sworn answers to interrogatories. So basically, they ask a question and you have to answer that question in a sworn manner, or provide testimony. And that looks like a deposition. So that is where whoever gets the CID demand for testimony comes down, usually to the Russell building, sits in a conference room and does what looks very much like a deposition, where they answer questions. The court reporter takes them down, a transcript is created. The difference being is that those are basically those deposition answers are locking in that person's testimony for purposes of that investigation. So if you do go to trial, or if you do find yourself in court and try to take a different position and you've answered sworn statements otherwise, that's problematic. And so the government's going to show the person taking the deposition lots and lots of documents, ask very pointed and specific questions. Generally speaking, the government will work up from the folks that they consider to be the lowest level of culpability. So it could be, a mid-level practitioner within a physician group depending on what's being investigated, and they'll work up all the way to the practice owner, the person they may believe to be most responsible for the conduct. Okay, so we talked a little bit about how these things are initiated. So I talked about the homegrown investigations with data analytics. But key TAMs remain or the most common way that civil investigations are initiated with the government. I think folks are probably generally aware of what a key TAM is under the False Claims Act. That's just where a whistleblower files a lawsuit on behalf of the United States. But folks may not understand exactly how, on the government side, that works. And so when I was a civil AUSA, a relator or relator's counsel would usually file a case under seal with the government. So it does not know they've been sued, along with a disclosure statement of all of the evidence that they have and documents that they have related to support their allegations of fraud. We would bring the whistleblower in for a sit-down meeting where we interviewed them and wrote up an interview report about all of the specific allegations. And I can tell you, in these meetings, they often get uncomfortable for the whistleblower because we're not only testing, figuring out what they know and what they're alleging, but why they're really there. We're asking very hard questions of them to figure out, is this just a person with an axe to grind? Is this someone that may be disclosing fraud but was actually participating in that fraud? That's a big one. And something the government really is out for. So we're evaluating not only the quality of the information, but also the leader herself. At that point, the government's off the races with investigations. So the CIDs that I mentioned might happen, informal interviews. And then when the government sort of has what it believes to be the skeleton or the bones of its case, frequently there'll be a dialogue with the target of the investigation. So if that's a physician practice, they will, with that practice's counsel, usually in a meeting with them where they, oftentimes in a PowerPoint presentation, not unlike this, will sort of walk them through the evidence that they have uncovered in the investigation and give the target of the investigation a chance to engage in a settlement dialogue. Sometimes the target wants to, sometimes they don't, and there are various reasons for that. But that's where the back and forth between a defense lawyer and the government becomes really, really critical, because there's lots of ways that the government's case can be chipped away at, can be degraded. You can provide the government with, because look, and we'll talk about this a lot in the coming slides, but the government frequently, they get a whistleblower allegation and they sort of are operating under the assumption that that is true. And it is just human nature that folks get tunnel vision, and they are essentially trying to prove a theory that has been posited to them. And they've not always considered countervailing or opposing arguments about that. And so when I was a civil AUSA, frequently I would sit down and I would do this presentation. I'd be like, oh, this is great. They're going to come running in the door with a check. And then they would come back and do a opposing presentation to me. And I would have a follow-up meeting with my agents. And I'm like, why didn't you tell me about this? I mean, there really is a lot of opportunity for degrading the government's case, chipping away at what they think is a really great case. And the good news is that, at least in my experience, the government is a lot more the government, generally speaking, wants to get it right. And so they're going to at least take seriously those arguments by a defendant. Whistleblowers, if you have to litigate with them, later on, frequently all they care about is the bottom line number, and they don't necessarily respond as well to, cogent and reasonable arguments.
One thing to add on, the whistleblower's complaint, it's a lawsuit and it's going to allege facts and causes of action and theories of recovery. And oftentimes, you might talk to your client about that, and that whistleblower, they don't know what they're talking about. We can disprove 19 of 20 facts that they've alleged. And that may be important, but for the government, it's not that important. The whistleblower complaint, I've told clients over the years, is just like a key to your front door of your practice. And the government can go in there and they can look at what the whistleblower is alleging, but then they can look at other things as well that they might be interested in. Oh, this is a practice that does a lot of imaging. Well, the whistleblower didn't really talk about relationships between the practice and the imaging companies, but that's something that's on our radar. So we'll ask about that in the CID. And all of a sudden, you just have, a case that starts with a whistleblower alleging a bunch of stuff that didn't happen, but the government has kind of, looked under the hood and says there's some things here we want to focus on that maybe the whistleblower didn't know about.
And certain of the what I would call less reputable whistleblower lawyers,
They're all.
well, there are some that have the ability to take only the really strong cases that, like, let's say they're, bringing a case on against a health system that the former CFO and chief compliance officer has come to them with allegations of, and they have the benefit of that, benefit of turning down all the bad cases. There are other whistleblower lawyers that, and usually that's because they've recovered hundreds of millions of dollars from the government in the past. There are other whistleblower counsel that don't have that luxury, that throw whatever they can against the wall and see what sticks. And what they want the government to do is exactly what Bob mentioned, is they just want them to start rooting around in this company's business, and they'll find something. And so the government knows who those lawyers are, and they take their complaints more with a grain of salt. Like I said, that sometimes exactly what Bob mentioned happens, which is you might send a CID about one thing, but in the course of an investigation, maybe your investigator finds something else. And you say, okay, well, we can't ignore that. And the government then proceeds to investigate that. But one thing y'all need to understand is that the vast majority, 8 out of 10 False Claims Act cases, are declined by the government. That means the government does whatever investigation is going to do and says, we are not proceeding with this case. And usually that's because they said the allegations are not borne out. So what that means is that even if you're a practice doing everything right and trying to do everything right with robust compliance and controls to try to prevent false claims from being submitted, you may find yourself on the wrong end of a CID and a False Claims Act investigation. It does not mean that you've done anything wrong. And if you engage counsel that can respond to the government's questions, oftentimes the government will say, okay, you're right, we agree, and they will decline to intervene in the case. Oftentimes that means that the whistleblower lawyers will decide not to move forward with the case and they'll dismiss. Sometimes they will decide to litigate on behalf of the government, even though the government's not formally joined the case. So the fact that 8 out of 10 are declined means that there are lots of investigations and that don't result in recoveries. And so I don't think folks realize that. I think they think that, basically if there's an investigation, if I get a CID that this is the end of the world, it's not. 8 out of 10 are declined. So on the False Claims Act side, there are some things that may look more familiar, may look more like what you're used to in a Medicare audit or a private insurer audit. And that in order to prove what they believe to be a universe of damages, the government is going to try to come up with what it calls a statistically valid random sample of records that it can request from a provider and then have an expert review. So sometimes if it's a billing and coding issue, that's a certified biller and coder. Sometimes if it is a medical necessity issue, it'll be a physician that practices in that area. And then they will present to defense counsel what they believe to be an error rate. And so one way the government tries to show recklessness or that something is not just an accident, so it sort of raises it to the level of False Claims Act violation, is a very high error rate. And a lot of times, the way they've calculated the sample or the way they've gone about the review, there's a lot of arguments to be made by defense counsel about why that's not proper, why it's not statistically valid, why it can't be extrapolated to all of the claims that are being investigated. And so that really is something important. It may look like a Medicare or Medicaid audit, but it's very much higher stakes. Okay, so let's talk a little bit about what to do if the feds show up. And by show up, I mean, show up at your door, at your practice's door, at one of your employees or former employees' door. this is really something that is going to happen in almost every case, whether it be criminal or civil. And so one thing Bob and I want to impress on everyone is that, first of all, practices are going to very frequently say, I haven't done anything wrong. I might as well cooperate because I'm going to look guilty. That is the wrong attitude. Like I said, agents can get tunnel vision. They have essentially a theory that they want to prove when they show up. And they're going to ask questions and usually be extremely friendly in doing so. Ask questions to sort of fit a narrative that they have. And one thing you can't do, and sometimes cooperation is the name of the game because they're not investigating you or your practice, they're investigating something totally different. But you can't know where you stand in terms of the government's investigation, whether you're a witness, a subject, or a target, unless you have counsel that talks to a federal prosecutor and says, hey, look, we want to help out in any way we can, but we need to know our status in this case. And then try to get as much information as they can from the government about what's being investigated so that you and your counsel can make an informed decision at that point about whether it makes sense to go talk to the government. Maybe they're investigating a DME operation that somebody in your practices NPI has been associated with, and maybe their identity has been stolen. If that's the case, the defense lawyer can hear from the government that you're not a subject, witness, or target, or you're essentially at most a witness and possibly a victim. And then that physician or the practice can provide records or answer questions without having to worry that the government's trying to, pin statements that you made on the practice. Oftentimes when agents show up, conversations are going to be recorded. And so everything that you say has to be with the understanding that it could be played to a jury at some point in the future. So that's just something to keep in mind.
Collegial and forthcoming, I mean, you guys are the ones having those conversations. How collegial and forthcoming is the other side when you're having that conversation?
Are you talking about when the agents show up? Or are you talking when we have the conversation?
When you get engaged on behalf of your client and you're the prosecutor, how collegial and forthcoming are they?
It depends on the investigation. Generally speaking, they're going to be collegial. They may or may not provide you a lot of information about what's being investigated. But what they will always do, in my experience, is tell you whether your client is a witness, target, or subject. That's critical information.
And they have an obligation to do that because, the witness has rights, right?
Right.
And the witness needs to know their status in order to, avail upon their own rights.
Yeah, and sometimes the answer is, well, without more information, I can't advise my client to come speak to you. And so that's very frequently a dialogue that takes place, and there will be what are called attorney proffers. And so it's saying, the defense counsel will say, hey, prosecutor, tell me what you want to talk to my client about, and I can sort of preview for you what they might say if we do sit down. None of that is a sworn statement or a statement that can be held against the witness. This is sort of dance that takes place between a prosecutor and defense counsel that's really critical and important to do, rather than just if an agent knocks on your door and starts asking questions and you say, well, I want to help, and you start answering questions, then all of a sudden, they're having a meeting with you where they're saying, well, you said this. And sometimes these foundational, what seem like really basic sort of background questions are things the government points to say you had knowledge about X, Y, or Z. So no question is innocuous. Every question matters, and you want to have a lawyer advising you about whether you should be answering those questions.
And oftentimes cooperation with the government is really in the eye of the beholder. Cooperation to the agent and the prosecutor often means agreeing 100% with their narrative. Cooperation oftentimes to some of our clients, particularly CEOs or owners, means I just want to go in there and meet with them and tell them why they're 100% wrong. And I'll be able to explain it all. And so that is kind of where we as lawyers step in and say, that may not be the best idea right now. Let us do our job. Let us talk to the prosecutors. Let us try to figure out where they are. And then we'll talk to you about where you are and see if there's overlap there or not. If there's not overlap, then we got some other things to talk about.
Yeah, I mean, certainly on the criminal side, prosecutors do not believe someone is cooperating unless they are fully disclosing everything that they have done wrong. That is a prerequisite to even allowing somebody to quote unquote cooperate. And so these are important things to think about, that your desire to help is commendable, and we share that desire, but you need to know the contours where you stand before you can provide that help. Yes, sir.
Yeah, so going back to the other slide, so I mean, if someone does show up and you're saying you should never speak to any agent without lawyer present, so what kind of verbiage are you supposed to tell the agent? Just that? So-
Yeah, no, I think that, and we'll get to this, there's a great segue to the next, the next scenario is that you should always stay calm, be very pleasant, thank them for showing up, tell them that you'd love to help, but that you need to talk to your lawyer first and say you're happy to take their card and get back to them after you've had a chance to chat with your lawyer. That gives your lawyer then somebody to call and say, hey, can we talk about this? Can you put me in touch with AUSA? These are important things to do. So, does that answer your question?
Yeah.
And so, yes, sir.
What's the difference between being a target and being a subject?
Yeah, it's sort of a spectrum, right? So a target is someone that the government believes, and this is sort of memorialized in what's called the Justice Manual, which is called the U.S. Attorney's Manual. A target is someone the government believes that if they can prove the allegations that have been made would have criminal culpability. And so that concept doesn't necessarily exist in the False Claims Act side, though the same concepts are used when you talk to them. So a subject is someone that is more in the middle, that is certainly has information related to a criminal violation, but whose criminal culpability depends kind of on what they say. So it is, and then a witness is on the other end of the spectrum, which is the government just wants information from them that is germane to the prosecution, but they don't really have any skin in the game in terms of criminal culpability. So subject is sort of right smack in the middle between basically a would-be defendant and someone that just might testify in the trial. It's someone who could go either way. They could end up being a witness or could end up being a target. Yes, sir.
So what if you get a letter and they're investigating your patient and they want information from your practice about a patient, like doing something, I don't know, they want the bills or something like that. So you're kind of a witness, I think. I don't know. Should we have a lawyer involved with that?
Yeah, I mean, anytime, so if you get anything from the federal government, from the DOJ, you need a lawyer because you need to make sure they hash out all of those questions on the front end. And it may be that, they've represented to your lawyer that there's a criminal investigation of your patient about something totally unrelated and that all they need from you is information, and that your lawyer may get comfort that you can just provide the information and answer any questions they have. But if it's coming from, not the DOJ, if it's coming from the local police or something like that, certainly the stakes in terms of your potential exposure are lower. But anytime law enforcement reaches out, it's a good idea to at least talk about it with a lawyer and get their take on it before you just start certainly answering questions. Okay, so let's talk about a few different scenarios. So scenario one is if federal agents show up at your practice. So as I said, in response to the first gentleman's question, you should always be very cordial, very calm, very pleasant. Thank them for showing up, offered to take their card. But if they start trying to ask you questions, you need to shut that down very nicely. Do not answer any questions. So even if they say, okay, we understand you want to get a lawyer, but we just had a few background questions. So if you answer those now, we can maybe avoid a lot of hassle down the road or something like that. That's not something you should do. You should not answer any questions whatsoever, even if it's about, who is employed in your practice. Any questions by a federal agent should not be answered without talking to a lawyer first. Now, if they show up with a search warrant, you don't have any choice. They get to execute that search warrant. So a few things you can do there is you need to look at the search warrant, obviously, make sure it's signed by a judge. and see what it gives them the right to search. Because they don't get to search things not specifically listed in the search warrant. It's gonna have a cover page, generally speaking, what's called an attachment A and attachment B. So attachment A tells them what they get to search, and attachment B tells them what they get to seize. And so you need to look at that, and if it says they get to search the front left room of the office, then you can tell them they're not allowed to go to the back right room, right? But more importantly, I mean, at this point, obviously, they're going to proceed with the search under the warrant. You should call your lawyer frequently. Your lawyer can get on the phone with you right then, and oftentimes get down there while it's still occurring. Sometimes these search warrant executions can take the better part of the day, depending on what's being taken. And I can represent that. Generally speaking, they're going to be very, very early in the morning. So if they're at a practice, they're going to probably wait until someone's there. If it's at home, it's going to be probably while folks are still asleep.
The other thing about search warrants that sometimes happen is, 10 agents might show up for the execution of the search warrant, and there's really only 3 or 4 agents that are needed to actually look for what they're, looking for, the documents, the records, hard drives, computers, things like that. Well, what are the other 5 or 6 agents doing? Well, they're waiting because they might want to talk to people as they're leaving practice. They might want to talk to patients if it's a pill mill operation. They'll oftentimes video the patients running out of the practice, and that becomes evidence at trial, but they might want to talk to some of those patients. They also may want to talk to employees. And this is where, getting a lawyer involved early is important, because one of the first things that the defense lawyer is going to do is going to call the prosecutor and say, our practice, our facility, we are taking the position as of now that we represent the employees until we determine whether or not we can represent them. Those are represented parties, and your agents can't tell them, hey, come and meet at the Starbucks down the street, and we want to talk about this. The practice has rights, the employees have rights, but you as a business owner, if you have a lawyer involved, can have those conversations with the prosecutor to assert the potential for an attorney-client privilege and attorney representation. And if they have an attorney, then the agents aren't supposed to go and, talk to them without an attorney present.
Yeah, that's right. So frequently speaking, the on-site interviews are as important as whatever is seized in the search warrant. If agents can interview 5 or 10 current employees executing a search warrant, that's going to give them a whole bunch of information they did not otherwise have. So they can ask about, when is this doctor there? Or when is this person doing this? Who's responsible for X, Y, and Z? They're going to get a lot of that type of information that they shouldn't be able to get without going through an attorney. And so sort of a corollary to what Bob said is oftentimes, even if it's not a search warrant, that they may show up on site with either a CID or an administrative subpoena to deliver, saying, hey, we got this subpoena for you. Oh, by the way, you can avoid this really expensive and burdensome process of complying with the CID or the subpoena. You just answer some questions and give us some records while we're here. Do not do that. That is sort of a ploy to really get a sit down interview with somebody that they think may have information about what they're investigating without going through counsel.
David, I have a question.
Yes, sir.
In regards to the data analytics piece that the government's really focused on now, specifically Medicare and all, is there a way that to avoid people from being the ostrich with their head in the sand, is there mechanisms in place to where, just like you have to get a background check before you can do certain things in life, like can a practice reach out and just say, hey, of our providers that we have, whether it's by MPI for the physician or whether it's MPI for our practice, like can they run data analytics as like a background check on your practice just to see how you're doing and let you know, like they had to put you like in a spectrum if you're on the radar, not on the radar, like, because I mean, you don't know what you don't know, but at the same time, you don't want to be naive to the fact that if there's anything to be proactive about, it's to be proactive from the DOJ coming and knocking on your door, right?
It's a really great question, and the government's really protective of its data analytics. So they're generally speaking, so they have a very, very expensive contract with a contractor that crunches these things, and they're not sharing that information. That being said, there is some publicly available Medicare billing data, and oftentimes you now see whistleblowers that are using that to. They aren't actually insiders from the company; they're just analyzing publicly available Medicare data and then bringing a case, I guess, a provider that they've never met or had anything to do with. So a practice could do its own analytics on the publicly available data, but the government's never going to say, here's the percentile you stand in on X, Y.
And there are some consultants that will do that and say, we can tell you where you stand in relation to your peers and whether your usage of certain codes or, where your coding curve is above or beyond, national norms.
Yeah.
So they have, data that they can platforms.
Yeah, because we regularly will take our coding information and apply it to specific, we work in the pain management space, right? And obviously, when we talk about pill bills and stuff, like we try to be as far away from that as we can be. But I think for us, what we're always trying to look at is, okay, you see the data and you act on it, but like how much is good enough in terms of making the necessary improvements so that way you don't continue to be on somebody's radar?
Sure. Yeah. I mean, it's a great question. Those consultants are one way to do it. The other thing to do, certainly with the pain management practice, I was the opioid coordinator in the U.S. Attorney's Office for many years. And so it's not just Medicare data you got to worry about there, it's the PDMP data.
Yeah, for sure. Yep.
So for folks not in the pain management space, the prescription drug monitoring program provides every time someone writes a prescription for a controlled substance, that goes in a database that the state runs called PDMP. That has become a very, very powerful law enforcement tool to see if somebody might be prescribing in excess of what they should and they're not worried necessarily about just healthcare fraud, but potential Title 21 cases, so like DEA cases for unlawful distribution of controlled substances. PDMP data is something that increasingly is being incorporated into an EMR platform, so you can sort of see where a specific prescriber's PDMP is. But there's also, they're also going to look to see, this patient that came to your practice had gotten prescriptions from, 6 or 7 different practices within the previous 2 months, and there are potential what are called doctor shopper patients. And they have data analytics that go through all the number of doctors. So if it's XYZ practice in Atlanta, they've prescribed to 30 potential doctor shopper patients within the last 6 months. They've also prescribed to 50 patients that traveled more than 100 miles to go to the practice. And so those are sort of what the government considers to be red flags for potential lawful prescribing. And so you can look at those same things. You can look at, presumably any pain management practices pulling the PDMP for a patient before the prescription. And so obviously that's one thing to make sure you're doing. But you can look and see how many of our patients are coming from far and wide. Those types of things the government.
And then lastly, with the introduction of artificial intelligence into a lot of EMRs, how do you think that's going to impact these data analysis that the government has as it pertains to, I guess, are you still culpable in the fact that if you're using AI as a tool to help you with your billing and coding information, what does that look like to ensure that you take the recommendation of a AI-based platform, and how does that impact your recommendation, I guess I'm saying?
So you're hitting on what I think is going to be a really hot topic in False Claims Act enforcement in the next few years. And so AI has proliferated at sort of a breakneck pace in healthcare thus far. It's not only in the patient treatment tools, but also in the billing and coding. The billing and coding tools, you really need to have a compliance program that is looking at where that coding curve comes out, relative to where human coders are coding it. Because if it's generating significantly higher reimbursement, and a lot of times these AI platforms, they don't care. They're trying to sell you their product, and they don't view themselves as on the hook for this stuff. And if they're selling you like, look, ours codes your E&M services to a level 4, more often than our competitors, well, that's potentially a fraud problem. And you've got to be looking at this from a compliance perspective and doing whatever you can. So if the government comes knocking, say, look, the AI platforms are a black box. They're never going to open up the hood and say exactly how they did it. And that's part of the problem. So you've got to be able to tell the government, we did everything we possibly could to make sure that this was consistent with our human coders. It's saving us money, but it was if, more conservative or the same amount as conservative as our human coders. And we asked all of these questions of the AI platform, and we did everything we could to make sure it was compliant. And so if there's a problem, go look at them. There was similar cases I was involved with EMR platforms recently for the Medicare had a meaningful use program and that incentivized providers to switch from paper records to EMR platforms. And there were several of the EMR platforms that were causing companies to submit false claims. But the DOJ couldn't really look to them and say, hey, you were the ones, so you didn't knowingly do this. And so they went after all the EMR platforms. We settled one here for $57 million against Greenway Health for doing that. The providers themselves did not face any consequences for that. So you need to position yourself to say, we asked every question, we tested it in every way we knew how. To the extent it was a black box and outside of our control, you go talk to them. Okay. So scenario 2 is sort of the same thing, but in a different location. So if agents show up to your home to do what's called a knock and talk interview, it's very frequently going to be first thing in the morning when they know you're going to be there, when you're going to be, off your game in terms of, how clearly you're thinking. They're going to show up and try to ask you questions. The same playbook here. Be very polite, calm, take their card, don't answer any questions. If they have any subpoenas or CIDs, take those and say, you'd be happy to get in touch with your counsel and talk to them. If they have a search warrant, yes, sir. If they have a search warrant, again, there's nothing you can do to stop them from searching the home. You need to confirm they in fact have a valid search warrant signed by a judge and look at the contours of what about your home is able to be searched, but it can be very disarming. I had a criminal healthcare fraud case of a gentleman down in the Tampa area. Apparently, there had been an agent shooting down in South Florida years ago during an execution of a search warrant. And so they basically flew a drone into his house and and basically covered the whole house to make sure there was nobody there that could harm someone, including flying the drone into the room where the target and his wife were sleeping. So a search warrant can be very, very, very disorienting. You got to keep your head about you, call your lawyer, and then be there to document where they're searching and what they're taking. They have to provide you an inventory of what they take, and so that's a legal thing they have to do. But short of that, most healthcare fraud investigations these days are going to be False Claims Act cases. That the criminal healthcare fraud cases are much more egregious conduct. We'll talk about a few specific examples, but it can be disorienting.
Yeah.
Yes, sir.
In either of these cases, are most of these suit and tie boys and girls, or are these gun toting? We want to intimidate the hell out of you in order to talk.
Usually speaking, they are not. When they're executing a search warrant, they're probably wearing the blue jackets with the yellow letters on the back, like you see on the news sometimes. If they're showing up to do an informal interview, they very frequently are not going to be showing a lot of force because any sort of intimidation gives a defense lawyer the ability to say, like, this was not a voluntary statement. That you basically were intimidating my my client into giving you information and sort of browbeating them. So I prosecuted the John Oxendine case recently. The agent that showed up at his door to do his interview was about 5'2", female agent. She had, sort of a mouthy little voice and is just laughed and giggled and the nicest person you've ever met in your life, and got really, really compelling information that was critical to the case. And so more frequently, you're going to have that than you do the show of force and intimidation. Now, some agents are old school and they wear suits just anyway. There's a guy, Jim Williams, I worked with, that always wears a suit. I mean, I'm pretty sure he wears a suit at home when he's just hanging out around the house. But usually they're not going to try to show big force, but they know what they're doing.
So that situation in Florida where they flew a drone into the person's house, even while they were sleeping, I guess they somehow accessed the home while the people were still sleeping to do that?
Yeah, I think that they knocked on the door, announced themselves, somebody, not the husband and wife, answered the door, like a family member, opened the door, and then they flew the big drone. No, generally speaking, they can't breach without first trying to knock. Now, if it's a potential, armed person, a violent armed person, they may breach without knocking, but in a healthcare fraud case, they're almost always going to knock. All right. A lot of times what's going to happen is agents are going to try to interview not you, but somebody that maybe works for you or your practice. So here, I mean, the answer is really the same, but the lens is a little bit different, and that person may call you and say, hey, there are people here trying to speak to me. What do I do? And so the thing I want to make sure you understand is under no circumstance should you prohibit them from speaking to federal agents. That could be viewed by the government as obstruction of justice. What you can and should do is advise them of what I've been telling you all right now, which is you don't have to speak to them without a lawyer present. We can connect you with an attorney. We have an attorney. And there are risks in you speaking to them without knowing your right, knowing what they're looking at and whether you're on the hook for potentially for you. And so that's an important thing to tell folks if they call you. Also tell them just if they've already spoken with the agent, sometimes, despite best efforts, they've already given an interview. Have them relay to you in whatever way you can, all of the information, all the questions that were asked and all the information that they provided in real time. As memories are going to dissipate, you want to document that because sometimes later on in a case, the government's interview report may come out and said that this person said X, Y, and Z. And they say, no, that's not at all what I said. And I took these notes right at the time about what I did say. And here's what I did say. And so that is really, really powerful thing to be able to do as opposed to just, having a federal agent to say, I got on the stand, get on the stand and say, this person told me X and not be able to challenge it.
Arbitrarily try to record it, or do they have to ask permission to record?
They don't have to ask permission to record. That's a good point. They can surreptitiously record audio. Towards the end of my career, it used to be that the common practice was to not record and just have them do an interview report. I decided towards the end of my career that it was much better just to have a recording so that there's not this game of I said this, no, I didn't, or he said this, no, I didn't. That there's a transcript or an audio recording that, if necessary, could be played to a jury. Conversation was. It also, I think keeps, when you're a prosecutor, the thing you're worried about is agents sort of stepping over a line and doing something they're not supposed to. And that keeps the agents, minding their P's and Q's about, not doing anything that could be intimidating to a witness and doing the things that if you're a good and conscientious prosecutor, you don't want people's rights being violated and that type of thing. So you should assume that if folks show up, they may be recording and there's nothing prohibiting them from doing that and they don't have to tell you. All right. And then finally, we've got the former employees. So when I was doing both civil and criminal healthcare investigations, former employees is generally where I started. Sometimes I just pull up LinkedIn, figure out who used to work there, and have agents go out and talk to those folks. They are not, there's not a risk that they are represented, that they're going to have, if the company has a lawyer, well, the former employee doesn't have a lawyer, so you can talk to them. So here, it depends on your relationship with the former employee. They may or may not call you. They may not like you at all. Maybe the reason they're a former employee is because they were a terrible employee and you fired them. And so you're not going to learn about this. But to the extent that you do, and they do call you and say, hey, the government showed up, asked me about, your billing for X, Y, and Z, you can do the same things we've discussed. You can tell them that they don't have to speak to the government without counsel and without knowing their status in the investigation. You can offer to get them in touch with a lawyer, whether it's your lawyer or if sometimes your lawyer can't represent both your practice and this former employee, and so referral to another lawyer. But there are things that can be done there. But the important thing to mention is not to prohibit them from speaking. I mean, not that you can prohibit a former employee, but you don't want to risk anything that might be viewed as obstruction.
1242.
All right. I'm going to quickly go through some of the recent cases involving physicians. I don't think it makes much sense. I'd rather get to what's important, which is any other questions you all have. But there are different types of buckets of investigations that you may see the government investigating. So medical necessity, this is a big one. So I mentioned the Oxendine case. This involved the former Georgia Insurance Commissioner, John Oxendine, and then a physician, Dr. Gallups, that he was associated with that ran what's called the Ear, Nose, Throat Institute. But this was a criminal case involving medical necessity. That does not happen a lot, and it tends to be more egregious. And so here, it's one of these things that if it sounds too good to be true, you should be asking yourself, if it sounds too good to be true, maybe it is. They got involved with this lab, Next Health in Texas, that they were, and Dr. Gallups with John Oxendine's help, was requiring all the ENT physicians to order toxicology and genetic tests for their patients. All those doctors were like, why would I order toxicology and genetic testing, for my patients? They don't have any relevance to my treatment of the patients. They're required to do it anyway. Turns out they were getting big kickbacks from Next Health for all the referrals that they were sending over there. But the scheme here was, we're not going to be in trouble because we are not doing this for federal payer patients. These are not Medicare patients. So the anti-kickback statute does not apply. That type of slicing and dicing is frequently going to get you in trouble, because what we were able to prove up was that this relationship caused you to refer to this lab medically unnecessary tests that were billed to various private insurers and tagging patients with very, very large bills.
Yeah. And oftentimes, this is a good example of, physicians or practices, it's too good to be true, it probably is. And a lot of times, somebody will hear about something, this is a great way to grow our business. I'm sure lawyers have looked at it. Or the company, the lab in Texas is telling me they've had it all vetted and checked out. So I'm just going to go ahead and sign up and start, doing this arrangement. Be wary of that. Do your own diligence. Call a lawyer who understands the kickback statute and what the potential pitfalls are before you just sign up and rely upon some third party to say, oh yeah, our lawyers looked at it, everything's fine. Because once you get in it, it's hard to back out if there's a problem in the arrangement.
And there are physicians throughout the practice jumping up and down saying that I don't need this, we shouldn't be doing this. That's something you should take seriously, right? This is the trial that Bob was talking about earlier. This is the first False Claims Act trial that went to verdict in the state of Georgia ever. And this was a doctor up in North Georgia that was doing what's called chelation therapy, which chelation is a type of therapy where, it's used to treat folks with lead poisoning. This was more of a sort of new wave practice where Dr. Adams took the position that everybody in modern society has too much lead in their blood. He was, spitting their blood and removing the lead. Had a bunch of patients that thought he was the greatest thing ever. But Medicare only pays for chelation for lead poisoning, and he was falsely diagnosing all of these folks with lead poisoning. And so, when you look at the Medicare data, it was why does everybody in this one area of North Georgia have lead poisoning? And that's a pretty easy case to go. But he could have resolved this case for $1 million or less, most likely, and instead found himself owing the government $27 million after the per claim penalties were assessed. This is another medical necessity case that I did while I was with the government. A doctor doing medically unnecessary cataract surgeries and a bunch of diagnostic tests. Same type of deal. I'll just point this out because urine drug testing is a big point of emphasis for the government. I'm sure it's not surprising to the folks in the pain management space, but sort of blanket standing orders for UDTs are looked upon by the government very disfavorably and have resulted in a number of both criminal and civil enforcement actions.
Or a standing order that always orders a confirmatory even before you even have the initial done.
Or if, a grandmother is, receiving, a Percocet, but then you're testing her for angel dust and everything under the sun, and the government's kind of look at that pretty skeptical. Upcoding, now these tend to not be criminal cases. These tend to be False Claims Act cases. So it's basically, you build a code that's too high. So you see this a ton with E&M, but also with provider assignment. So billing mid-levels for under the physician's NPI. So mid-levels, as I'm sure most folks know, are reimbursed at 85% of what the physician's reimbursed at. So you will frequently get cases in which the government says you should have billed this under the mid-levels. E&M upcoding. So this is office visits, right? So it's, for both new and established patients, you can bill a level 1 through a level 5, and providers that are really pressing the envelope on where they bill, coding things 4s and 5s are going to get looked at with some heavy degree of skepticism. Same thing with the heavy use of modifier 25. So a modifier 25 is just a code that can be affixed to an E&M claim that allows it to bypass an automatic edit that CMS has that says you can't bill an E&M claim on the same date as a service is performed. But modifier 25 is when there's legitimately a separate thing that's being looked at for that patient. You're going to fix a modifier 25 to that and say we're allowed to do that. Got heavy use of modifier 25 within your practice. You should look at that and make sure that is that's appropriate, because there have been a number of cases, not unlike the Skyline urology case. This is just more of the E&M upcoding. So anti-kickback statute has been for years and will continue to be one of the main tools the government uses for the False Claims Act. So there's a very recent case out of this district for American Health Imaging and Scott Arendt. So interestingly here, the government settled not only with the practice, but also its former owner, who was the founder and CEO of the company, who I think they'd sold off to private equity, but the government held him personally responsible for this settlement for over $5 million. So AHI was alleged to have provided a bunch of kickbacks to doctors for referrals, including, among other things, SEC championship football tickets and that type of thing. So just know that the AKS violations are going to be a big emphasis for the government pretty much forever. A lot of AKS violations in the hospice space, including, and a real emphasis I've noticed in recent years has been paying folks to be quote unquote medical directors. If someone's going to be a medical director, what they're doing for the practice needs to be significantly documented, and their compensation cannot be tied to the volume of referrals that they make. And then this is a case that I prosecuted on the criminal side, and I just want to note this because this is an example of how practices may get an inquiry from the government, and then it turns out nobody with that practice, the practice or its physicians have no responsibility. But DME fraud is one of the biggest areas of criminal enforcement in the healthcare fraud space. The upshot of these things are that call centers, usually in India, call folks, get their call Medicare beneficiaries, promise them free stuff, get them to agree to it, and then send them every leg, ankle, neck brace under the sun. At trial, we put federal agents, had them wear all of the braces that an individual patient may have gotten, we called it the mummy suit. And it will really show just how most of these patients did not need this. And frequently you'd have them saying, I have them return the braces saying, I didn't need this or want this. Well, in order to do these, they have to get a physician order, a prescription for the braces. And so we started noticing a ton of physicians on here, and we'd reach out to both them and the practice and saying, we have no idea what you're talking about. Well, it turns out there was an operation in the Philippines, basically just slapping doctors' names and MPIs on these orders, and basically you stealing their identity in order to carry out this scheme. And so they ended up being victims for us in the case, right? So they wrote some very, very compelling and powerful victim impact statements about how they faced licensure challenges. Their state licensing board had threat to licensure because they had noticed some of these things, and patients had complained to the licensure board. But I also want to point out that the opposite is often true as well. So I've reached out to practices before and said, Dr. Smith, you give us information about this, about him prescribing DME. They said, well, he doesn't prescribe DME. He's an OBGYN. Turns out Dr. Smith was at night clicking for cash, and we were able to put his bank record showing he'd been paid $500,000 from a telemedicine operation to click 1,000 orders within an hour at night. So sometimes if your physician tells you that they've not been involved with something, you need to take that with a grain of salt. I mean, obviously believe them, but trust but verify. And so I've seen both sides. Stark Law is sort of coming back in vogue with the federal government. So the Toomey case years ago that sort of paved the way for this, these sort of mega settlements, mostly with large hospital systems, it started to crop up again. So as I mentioned, this is something to be very, self-referral law needs to be something you're very, very concerned about because it is a strict liability statute. So if you violate it, there's not really an argument that Bob or I can come in and say they didn't mean to do it. You either violate it or you don't, and you've got False Claims Act problems. Opioid prescribing, we've touched on this recently. This is another case I was involved with. One thing to know about opioid prescribing on the civil side. False Claims Act, the False Claims Act can be triggered if they've done it for federal beneficiaries, but the Controlled Substances Act, so this is the same law that we used to put in pill mill doctors in prison, also provides for civil penalties against those that unlawfully prescribe controlled substances. So this settlement involves significant amounts of Controlled Substances Act penalties for medically unreasonable prescriptions. Doesn't matter if they're Medicare or Medicaid beneficiaries, they apply to everybody. And so in the opioid space, this is another significant type of tool the government may have. So you need to be aware of that. And the difference with these types of cases is that you may often see what DEA drug diversion investigators showing up instead of FBI agents, HHS OIG agents. These folks may be saying, and frequently, sometimes they are just doing a routine audit, but it's not always a routine audit. And so don't treat them any differently than you would an FBI agent showing up at your door. You just take their information, get in touch with your counsel. All right. Briefly, this is just wanted to mention, and John mentioned this on the outset, that you can get insurance for this type of thing, which, from my perspective, just in terms of the general scope of exposure, at least in an office the size of U.S. Attorney's Office in Atlanta, it wasn't really worth our resources to do a full-scale investigation if folks didn't have at least potential for more than $1 million in culpability. And so if you're getting a CID, if the government's poking around and suggesting you've done something wrong, it's safe to assume that they think that you might be on the hook for more than $1 million. And so insurance can really help, help avoid some of those monetary disruptions. It's something to consider. And John obviously can speak more about that and is the expert there. But we've seen an increasing amounts of policies that cover both defense costs and the actual settlement.
The one thing that generally an insurance policy cannot cover as a matter of public policy is the amount of money that the government says you shouldn't have gotten from Medicare. So if they said, all right, you shouldn't have gotten $500,000 from Medicare, but your exposure is 1.5 million because of treble damages, you can't get insurance for that first 500,000, but the per claim penalties or the multiplier generally policy for that, along with, very importantly, your defense costs. And the defense costs in the investigation stage can be considerable, where you are having to do electronic discovery, you're having to gather the emails over a 7-year time period for 10 custodians in your office and put those into a review platform, do keyword searches. All those things can be expensive, and having insurance, even if you're not culpable at all, even if eventually the government's going to say, all right, we're satisfied, we're not going to go further with this. That's still a cost that businesses will have to deal with, that, having insurance and having the ability to tap into coverage for those defense costs, even in the very beginning, is important.
And same thing with consultants. Sometimes you have to hire your own consultant to sort of go to battle with the government's consultant, saying that these claims were medically unnecessary, or this biller encoder saying that this should have been a level 4 versus a level 3. I'm sorry, level 3 versus level 4. So it's not just attorney's fees. There are lots of costs that come into play, and insurance can help sort of smooth that. All right. Most importantly, who has additional questions?
That's your chance. Free legal advice, not quite.
Yeah, not legal advice.
Not legal advice, just.
So the guy that did telemedicine, what was he was just clicking on like multiple, like, I guess what I'm asking, I've never done telemedicine, but just curious, is that like a black box like we shouldn't get into, or what was
no.
the problem?
Telemedicine is a very useful tool that has become increasingly common, certainly since COVID. Telemedicine's great. Telemedicine in the way that they were doing. So this is the way this works. And in the case that I put up before, though there had been no doctor doing any telemedicine, but frequently in the DME fraud cases, you have quote unquote corrupt doctors that are clicking for cash at night. So they might have a different job during the day, and they're just basically clicking through orders saying this order, this person can receive these braces over and over and over. That's not real telemedicine, right? Those doctors were not those patients' doctors. And generally speaking, they never actually did a telemedicine video, audio visual encounter. They were just clicking orders and saying that they had. If someone's actual doctor wants to do telemedicine and complies with the Medicare regulations about telemedicine, that's absolutely something that's great. I do that with my doctor all the time. And have, certainly during COVID, when they didn't want folks coming in, they did a lot of the encounters via telemedicine, and the rules say that you can do that, and that's a great thing to be able to do. But what you see in the DME space and also the genetic testing space are basically doctors that are either doing a perfunctory telemedicine encounter or none at all, and saying that they have, and just because all they're paying for, these sort of the criminals running the DME or genetic testing schemes are they're just paying for an order, and that's a textbook violation of the anti-kickback statute.
How in the world do they think they could get away with it?
Because in part they do. I mean, there's so much of this, it's just whack-a-mole. And so they will close down a company, they will open up a new one, they will open up a different company in a relative's name or another associate's name. And it's just, in that case that I just put up on the board, they built $125 million in 18 months. And so, and then we got, and that the individual running that scheme got 9 years in prison. But frequently these folks are, closing them down, or they'll be offshore. A lot of folks are in countries where there's no extradition treaty. I mean, these are, this is healthcare fraud, but these are not mom and pop providers that are doing the wrong thing. These are full-on criminal organizations, often located internationally.
They need someone with prescriptive authority, and it's not just, it could be mid-levels as well. I represented a hospital medicine practice where one of their nurse practitioners, in the emergency room, however many shifts a month, on the side, she was doing exactly what Dave said, clicking for dollars. She was, authorizing orders for DME all over the country, even though she'd never had any encounter with the patient. She got indicted, prosecuted, and in federal prison now.
And they convince the provider that they can't get caught or can't be identified or something.
Do we have one on the chat?
We have
Yeah,
two.
I had a quick question. I'm online. You talked about this special investigation unit. You go to Anthem, and Anthem, sends these requests across for them to review charts, and they look at these charts and say that the notes are looking similar. But we are not going to be able to differentiate. Hypertension is hypertension. If I start Norvasc on one patient and the other patient, it's going to look similar. And most of us with EMRs in today's world have dot phrases. We just put the dot phrases in, and so the same dot phrase populates across all charts. So then is that something which you should challenge, or is that something considered because it's looking similar, because the diagnosis is similar, the plan is similar, the treatment is similar, the education is similar. I'm not going to discover new education or new treatments for each diagnosis. So is that something arguable with these companies, or not arguable?
It's very much arguable. And this is a common thing that we see a lot in these cases where the EMR pre-populates sort of language that can be used. And so records across a number of different patients look, very similar. If you can, support the medical necessity of it, that's absolutely something that can be pushed back upon. I can tell you that, I know it's become industry practice and industry standard, but the government hates the same language in every record.
They hate cut and paste.
They hate cut and
They're
paste.
trained to hate cut and paste from,
But
day one at age of school.
cut and paste does not mean false. Now, in some cases, if demographic information about the patient is cut and pasted such that it looks like it's not even about the same patient, that is harder to explain. But
Sure.
But yes, there's absolutely ability to push back on those things. And the government cannot prove that the patient did not have hypertension just by showing that the language is similar to another patient.
Because you mentioned about Anthem, and I think we are a small office. We get some letters and we just send it to them. But they're coming back and saying that, hey, your notes are looking similar. And but when you go to Anthem's meetings, do these people even understand how EMRs work? These people who are reading at charts, they are not, I doubt they're clinicians who work in real world. They are looking at charts and, hey, it looks similar, diet, exercise.
It's a good question. In those meetings that I was talking about, the quarterly meetings for the healthcare fraud working group that I would go to as the government representative, they're not telling me about their just general audit practices. They are raising their hand when they think that they've uncovered fraud that the government may want to investigate. And so I can't think of any meeting where they were telling me about, similar language across patients for hypertension or something similar. It was always, much more egregious. Now, I'm certain that within their audit department, maybe not necessarily the SIU, but that they're doing record reviews and they're making, payment determinations that oftentimes may not be supported. Not every payment determination or denial gives rise to a fraud, waste, or abuse case. And so that sounds very much more likely to be the subject of a routine payer audit and not a DOJ type False Claims Act or criminal investigation.
Correct. But I'm just thinking it. I'm not talking about this, but in a large practice, if there are 10, 20 doctors and pretty much everybody is using similar languages, and if an insurance company or Anthem comes by and sees 100 charts, everything is going to look similar because most patients are having the top 5 diseases: diabetes, hypertension, cholesterol, blah blah blah. So overall, it's going to is that something in the horizon these people are looking at and are being educated about or know about? Hey, this information is going to look similar across patients, or are they looking at that as fraud?
I mean, they have clinicians and subject matter experts in every area, and so does the government. And so that's something that they should understand. But sometimes I would imagine in a payer audit, it's just like in a government investigation where it's incumbent upon the provider, in the case of a DOJ investigation through counsel, to educate the other side about, is to say, like, look, this looks similar because very many patients are similar. There's similar comorbidities and that type of thing. And this is not suspect and it's still payable. Or in the case of a DOJ investigation, it's still, it's not a false claims act violation.
We got one more question here.
What if an employee does not have a lawyer? Where can they locate a lawyer quickly?
Okay. So, yeah. So if an employee if a current employee or even a former employee does not have a lawyer and they call the practice and the practice has a lawyer that they use, should reach out to your lawyer and then your lawyer can help arrange for that person to get a lawyer. Oftentimes, as Bob mentioned, especially early in a case, your lawyer can be their lawyer at the same time. Now, and sometimes there are reasons where, you need to get another lawyer for an individual that's not the same lawyer for the company. But that can be done through your lawyer with another lawyer that your lawyer trusts. And so if Bob or I get a call about that type of thing, and it looks like there might be some sort of conflict, some reason we can't represent the employee, you better believe we've got other individuals we know around town that do this all the time that can represent that employee.
Great. Are there any other questions here before we wrap up? Oh, I know these guys will stick around for a little while if you do have questions. From a contact information standpoint, do we have Gil's contact information on the slides, or could you just throw out a phone number in case some of the people online have an interest in getting in touch with you afterwards? Oh, there's the firm name.
And I've got cards as well, and I'm sure Bob does too. And we're also on the firm website with all of our good contacts. So feel free to come up and get a card and say hello after the fact. If anybody on the chat needs our information, we'll certainly shoot that all to John so it can be distributed.
And the folks online, our main number is 404-523-5300. Call and ask for either David or myself. So Google us and our information will come up pretty quickly.
Okay.
John?
On the insurance, is it E&O insurance or?
It's called billing errors and omissions insurance, and the way Bob described it is exactly right. It won't pay for restitution, but it will pay for attorney's fees and fines and penalties associated with the investigation. Somebody online had a question?
Yeah, this is Karen Beard. How are you doing? Over at Medical Management. Well, one thing, just a little maybe advice to the person who just talked about the documentation. I've had to do chart reviews myself, and I had one cardiology practice. By the end of the review, I could have written the chart myself without ever seeing the patient. They use so many macros. But the place where it is really good to make sure that you're identifying this, that you really recognize this person as an individual is in the presenting symptoms. Well, we saw this person last year, we're doing this, we're doing that, and some personal references of that. And at the end, don't just say, gave the patient the opportunity to sit, ask questions, and recommended follow-up. I mean, give a little bit more detail to show that you are dealing with individuals. And because I have seen people that just really gotten messed up on using so many macros and forgot to check them. And so they're saying that females were having normal prostate exams when it didn't. So that's one thing. But I had one real quick question, that if your case, the case that you're being hit with the feds is a whistleblower case. And number one, when do you find out who the whistleblower is? And if it's an employee, what can the employer do? And if they don't want that person to stay, obviously, but what's the rights and privileges of the employer?
So you find out who the whistleblower plaintiff is when the case is unsealed.
Okay.
Frequently speaking, that's when the government has concluded its investigation and has made a decision whether to intervene and take over the case or not. There are some occasions in which the government may agree to do what's called a partial lift of the seal, where they will provide you a copy of the complaint during your discussions with the government so you can see what's been alleged by the whistleblower. That is not a common occurrence, but it does happen, and there are times when that should happen. In terms of what you can do to a whistleblower that's within your practice, as I mentioned, there's the anti-retaliation provision of the False Claims Act, and so certainly firing or demoting someone that has blown the whistle, if you find out they've blown the whistle, and frequently, it's frequently you can determine even before the complaint is unsealed who the whistleblower is. It's oftentimes obvious to a physician practice who it might be, and sometimes you can do things within a company's IT system to figure out who's downloaded or emailed a bunch of documents to their personal account related to what the government's asking about. But if you do find out who they are, any adverse employment action is going to give rise to potential real culpability under that anti-retaliation provision.
if that's the cause of the retaliation, if that's the cause of firing the person.
Yeah.
Sometimes employees, kind of know they're on thin ice for other reasons, unrelated to their, unrelated to whatever the compliance issue is. But they'll try to cloak themselves about, well, you can't fire me because I want to go to the government, or you can't fire me because I know about these things about your practice. And that becomes almost like a labor law issue. And it becomes, very fact specific about, well, if the cause of this person's demotion or termination is unrelated to what they're complaining about, or if what they're complaining about isn't really a False Claims Act violation, then you do have rights and ability to part ways with that employee. But I've seen several times in the last 5 or 6 years where employees think they can kind of protect themselves from any adverse employment action just by saying compliance. And that's not always the case.
In the interest of time, we're going to go ahead and wrap things up. Bob and David will be available to you. And certainly we'll stick around afterwards. Thanks everybody for coming, and really appreciate y'all being here.
Thanks, everyone.
Thank you.